Legal aspects of education. A critical component of becoming a teacher is to develop a basic familiarity with legal perspective. Teachers not only need to understand the law as it relates to their rights and responsibilities, but also they must be able to be knowledgeable about the rights of their students. Learning the legal aspects of education begins with developing an understanding of the importance of the U.S. Constitution and the Bill of Rights. Enabling and legislative agents, people of the state and their rights under the U.S. Constitution, Constitution of the States, statutes of the state legislators, state board policy, local school board policies. Administrative agents, local administrators, state superintendent, state educational department, opinions of Attorney General, U.S. Department of Education, and the President. Interpretive agents, decisions of the state courts, decisions of district courts, decisions of the U.S. Supreme Court. Some laws are developed out of legislative processes. These are referred to enabling laws, or those that provide opportunity or make it possible for educators to do certain things. Also, administrative law is made up of the rules and regulations that the executive branch of the government creates. One of the legislative branches of the government has established a new statute or policy, government office, or such the U.S. Department of Education or the State Department of Education will develop rules and procedures. Once the legislation is enacted into law and the rules and procedures are in place, if a question of interpretation is raised, then the judicial interpretive process is engaged. A judicial process also is used when it appears that a law has been violated. The interpretations of the state and federal court systems decisions form a body of case law that are further used for other court cases that need to be decided. The U.S. Constitution is the fundamental law for the nation. When Congress develops a new statute, it must be in accordance with the U.S. Constitution. When the state legislators develop a new law, it must be in accordance with the U.S. Constitution and the state constitution. 3 of the amendments of the U.S. Constitution are particularly significant to the government of education, both public and private. The 10th Amendment. The power not delegated to the U.S. by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or the people. The U.S. Constitution does not specifically provide for public education. However, the 10th Amendment has been interpreted as granting this power to the states. Therefore, education in the U.S. is not nationalized as it is in other countries of the world. Each state has to provide for the education either in its constitution or as basic statutory law. First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press or the right of the people peaceably to assemble and to petition the government for the readiness of grievances. First Amendment has been applied respectively to issues confronting public education. The Establishment Clause. Congress shall make no law respecting an establishment of religion. 2. The Free Speech Clause, which has directed implications for teacher and student rights. The 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of a citizen of the U.S., nor shall any state deprive any person of life, liberty, and property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The application of the 14th Amendment to public education primarily deals with the Equal Protection Clause, nor shall any state deny to any person within its jurisdiction the equal protection of the law. Our nation has strong religious heritage. In the colonial times, education was primarily a religious matter, and many of those who attended schools were destined for ministry. However, the rightful role of religion in public education still continues to be debated. Should public funds be used to support students in religious schools, or can prayer be said at a high school commencement services or in classrooms? Are questions to be asked. The First Amendment is interpreted as being applicable to the states by the 14th Amendment. A state law requirement a daily prayer to be read in the classroom throughout the state could be interpreted as depriving persons of liberty, and as the state establishing a religion, or at least prohibiting the free exercise thereof. Court cases related to the separation of church and state can be classified into three categories. 1. Those dealing with the public funds to support religious education. 2. Those dealing with the practice of religion in public schools. And 3. Those dealing with the rights of the parents to provide private education for their children. Lemon v. Kurtzman. Legislation to provide direct aid for the secular service to non-public schools, including teacher salaries, textbooks, and instructional materials. The decision court ruled the legislation unconstitutional because of the excessive entanglement between government and religion. The court poses three questions that have since become known as the Lemon Test. 1. Does the act have a secular purpose? 2. Does the primary effect of the act either advance or inhibit the religion? Or 3. Does the act excessively entangle government and religion? Child benefit theory. The use of public funds to provide secular services has led to the concept referred to as child benefit theory. More recent decisions supporting the use of public funds for transportation and textbooks for students in private schools have generally been based on child benefit theory. This theory emerged out of the commentary about Everson v. Board of Education case. The reasoning was the transportation and books provide benefits to the child, not to the school or the religion. No Child Left Behind provide assistance to both public and non-public school children. For example, Title I essay, which deals with assistance for education of the children from low-income families, states that children from families attending private schools must be provided services in proportion to their numbers. Statement on church and state related to public funds and religious education. Laws and policies that have effected of establishing religion in schools will not be upheld by the court. The use of public tax funds to pay for secular textbooks and loans to students and transportations of religious schools children have been upheld by courts. Use of public tax funds to pay salaries of teachers in religious schools has not been held up in court. The use of public funds to pay tuition of religious school children has not been held up. In Minnesota, tax deduction has been upheld by parents of children in public and private schools. Special support services such as speech and hearing teachers may be provided to students in religious schools. Religious schools may be reimbursed by administrative costs of standardized tests, test scoring, and record keeping required by the state. Public tax funds may not be used in support of public school teachers offering remedial or enrichment instruction in religious schools. Santa Fe Independent School District in Texas adopted a series of policies that permitted prayer initiated and led by students at home athletic games. Court noted this policy likewise does not survive a physical challenge because it is impermissible imposed upon the student body of a majority election on the issue of the prayer. In other words, the district would be imposing a particular religion activity on a majority on all, a clear violation of the Establishment Clause. Evolution. Darwin theorized that today's animals and plants were results of natural selection over thousands of years, in other words, evolution. Some religious perspectives and a large portion of the population view evolution as unproven theory. 1925, the state of Tennessee v. John Thompson Scope. The teaching of evolution in science class, the teacher was guilty. The decision was later overturned on a technicality. Segregation, desegregation. A troubled problem for U.S. history has been the history of legal and social separation of people based on their race, in other words, segregation. Up until the middle of the 20th century, the public school system in many states contributed to this problem through the operation of two separate sets of schools, one for white and one for African Americans. Segregation schools were supported by the courts, state laws, and official actions of the state and local government administrators. This type of segregation was based in illegal and official action and called de jure segregation. Since 1954, the courts and communities have made an intensive effort to abolish the racial segregation of school students. Called desegregation, a major instrument the court have used to accomplish this end has been integration, often done by busing students to achieve a balanced number of students in terms of race in each school within a school district. Over the years, these efforts to integrate the schools have had mixed success, and now there is an increased concern of over-segregation of schools based on where people live. Segregation or resegregation caused by housing patterns and other non-legal factors is called de facto segregation. Before 1954, many states had laws either requiring or permitting racial segregation in public schools. Lower courts adhered to the doctrine of separate but equal. In a court case, Plessy v. Ferguson, Louisiana law required railroad companies to provide separate but equal accommodation for black and white races. In May of 1954, the court said the separate but equal doctrine had no place in education and that separate facilities are inherently unequal. In 1954, the time of the Brown decision, to 1964, little progress was made in eliminating separate schools. In May of 64, referring to the situation in Prince Edward County, Virginia, the Supreme Court said, "There has been entirely too much deliberation and not enough speed in enforcing the constitutional rights which were held in Brown v. the Board of Education." The Civil Rights Act of 1964 added legislative power to the 1954 judicial pronouncement. The act not only authorized the federal government to initiate court suits against school districts that were lagging in desegregating schools, but also denying federal funds for these programs that discriminated by race, color, and other origins. Plessy v. Ferguson, railroad companies should be required to provide equal accommodation for African American and other races. The court indicated its decision that the 14th Amendment implied political, not social equality. Separate but equal was established. Brown v. the Board of Education, legal separation of facilities. The separate but equal doctrine has no place in education, and dual school systems are inherently unequal. Griffin v. County School Board, Prince Edward County. Whether a court may close its schools and provide assistance to private schools for whites only, the court instructed the local district court to require the authorities to levy taxes to reopen and operate non-discriminatory public school system. Board of Education, Oklahoma City v. Dowell. The conditions under which social school districts may be relieved of court supervision. Court supervision was to continue until segregation was removed from every facet of the school operations. Freeman v. Pitt. Whether court supervision may be withdrawn incrementally and whether a school district is responsible for segregation based on demographic changes, the district court is permitted to withdraw supervision in discrete categories in which the district has achieved compliance. More than 500 school districts have experienced some sort of federal court oversight. Instead of schools and communities becoming fully integrated, there is a clear trend to resegregate, especially in urban areas. As well as intentioned as the effort has been to de-jure segregation or de facto segregation is increasing. Schools continue to be challenged to ensure all students receive equal access to a quality education. This current strategy for achieving this is some form of race-conscious alignment of students. Strategies such as magnet schools include consideration of diversity in admissions and giving priority to siblings in school assignment are being tried.